I pray to your lordships, it's my considered opinion, and I plead before your lordships, to hold that Shiv Sena name belongs to Thackeray, to hold that the faction of Shinde cannot have the symbol. And the fact that they have enjoyed the benefit of that symbol is not a case of equity. It's a case of illegitimate use of a symbol. It should be frozen. If he can't have it, I can't have it, it has to be frozen. And the name belongs to me.
This is your alternate.
This is my alternate submission. What's the relevance of that? How is a resolution of the legislative party marked to the governor? What role does the governor have to play? And Subhash Desai held that action of the governor to be illegal. Respondent MLAs refused to attend the meeting of the Shiv Sena Legislative Party on 22/6. Who was the chief whip? Sunil Prabhu. He called for a meeting. They gave a reply. You have no authority to call for the meeting because we have our own whip, namely Gogavale. Eknath Shinde also released a statement that his group had the backing of a national party. Normally, they may dispute it, but I think this court has enough experience to ferret out and infer the reality of the situation. The leader of the opposition, Devendra Fadnavis, met the Honorable Governor and requested him to direct the holding of a floor test. The Honorable Governor then called for a floor test relying on the resolution of 21/6. Please don't interpret it in the 10th schedule for allowing defections to take place, because that's a sin. Otherwise, make sure that you do not destroy the very foundations of our democratic process. Then, Miraj, what are the undisputed facts, Miraj? Miraj, I just want to make one thing clear. I am not going to go into any documents provided by me, because questions have been raised about those documents, Miraj. I am not interested in, Miraj, trying to prove to your lordship that these are genuine. I will go by the undisputed facts that both sides agreed upon and then make my submission. So what are those undisputed facts? 21st of June, 26th of June. Para 35, the following undisputed facts are sufficient in law to attract disqualification. While camped together in same hotel in BJP-ruled state of Gujarat, Surat, on 21st June, respondent MLAs passed a resolution of Shiv Sena Legislature Party seeking to change the chief whip appointed by the political party and reaffirming Eknath Shinde as their group leader as a direct affront to the political party. Further, they marked a copy of this resolution to the Honorable Governor, who had no role whatsoever in the matter, demonstrating their intent to topple the government. Manoj, I want to show this document to your lordships, where they show, Manoj, they're a copy to the governor. Kindly have a look at that. That's at page 117, Manoj, of the convenience compilation. Now, Manoj, this is undisputed, this document. It's a legislature party resolution. So we go by that. It's their document. That's dated 21st of June. Resolution of the meeting of Shiv Sena, Maharashtra Legislative Assembly. And it's marked to the governor. Then there's signatures below. And it's marked to the governor at page 123. What's the relevance of that? How is a resolution of the legislative party marked to the governor? What role does the governor have to play? Because that's how the governor called for a floor test. And Subhash Desai held that action of the governor to be illegal. So all that the speaker has said is entirely contrary to the findings of the Constitutional Bench. So I just wanted to show this to your lordship, Malas. Yes, now come back, Malas, too. So this is undisputed. These two acts by themselves, they are liable to be disqualified. Respondent MLAs refused to attend the meeting of the Shiv Sena Legislative Party on 22/6 on the instructions of the party president by disputing the authority of the chief whip of the political party to issue a notice. Who was the chief whip? Sunil Prabhu. He called for a meeting. They gave a reply. You have no authority to call for the meeting because we have our own whip, namely Gogavale. This is an undisputed fact. That itself, this is the third fact which makes them liable for disqualification. Then come the next that is 22/6 onwards. Respondent MLAs traveled from Surat to Guwahati and stayed in the same hotel. It was reported in the news that the logistics of the respondent's stay at the hotel were closely overseen by an MP and 3 BJP ministers close to the Chief Minister of Assam, and BJP Yuva Morcha leaders were seen to be staying in the hotel in turns. Eknath Shinde also released a statement that his group had the backing of a national party. Now, they may dispute it, but I think this court has enough experience to ferret out and infer the reality of the situation. They formed the government on the 30th with the BJP, and they traveled to Surat and then to Guwahati. That itself is telling. And you don't have to produce evidence to show that.
BJP rule states.
I think now you know, I know, they know. Now the answer. According to us, this also should be undisputed. Anyway, next. That's why I made no comment there, Madhasa. Then kindly 28/6. The leader of the opposition, Devendra Fadnavis, met the Honorable Governor and requested him to direct the holding of a floor test. The Honorable Governor then called for a floor test, relying on the resolution of 21/6. That's undisputed. That itself will result in disqualification. The next. On 30th June, Eknath Shinde, with the support of the respondent MLAs and the BJP, met the governor and staked his claim to form the government in Maharashtra and was sworn in as chief minister, without reference to the political party. Undisputed fact. Then on 3rd of July, respondent MLAs admittedly voted for Rahul Narvekar, the BJP candidate for the speaker's election, despite being another candidate, Shri Rajan Salvi of the Shiv Sena. At that time, there was no question of another political party. Now, that's the 21B, undisputed fact. The others are 21A. This is 21B. And 4th of July, all respondent MLAs admittedly voted in favor of the government formed by Shiv Sena, by Shinde, with the support of the BJP in the confidence vote on 4/7, undisputed, again 21B. So it is respectfully submitted that the actions of the respondents resulting in toppling of the MVA government, of which the Shiv Sena political party was a part, and the formation of a new government with the support of the opposition BJP is a classic case of political defection in violation of the 10th schedule. This honorable court has in several decisions held that the mere meeting the governor with the opposition party amounts to violation, this is held in Rajendra Rana, amounts to violation of para 21A. In the present case, the respondents have not only supported the opposition party in toppling the duly elected government formed by their party, but rather they have themselves formed the government with the support of the opposition party. Reference is invited to the decision rendered in Rajendra Singh Rana. Para 48. The act of giving a letter requesting the governor to call upon the leader of the other side to form a government itself would amount to act of voluntarily giving up membership of the party on whose ticket the said members had got elected. Clearly, from the conduct of meeting the governor accompanied by the General Secretary of the Samajwadi Party, the party in opposition, and the submission of letters requesting the governor to invite the leader of the opposition party to form a government, as against the advice of the chief minister belonging to the original party to dissolve the assembly, an irresistible inference arises that the 13 members have clearly given up their membership of the BSP. No further evidence or inquiry. This is what I'm asking your lordships to infer. No further evidence or inquiry is needed to find that the action comes under paragraph 21A. The very giving of the letter to the governor, requesting him to call the leader of the opposition to form a government by them itself would amount to the voluntary giving up of membership of the original party within the meaning of paragraph 2. And then, in Srimat Balasa Patil, is another, I think it's three-judge judgment of this court. Karnataka matter, we did it together. Says the speaker in the impugned order has taken note of the surrounding circumstances, including the conduct of the petitioners from February 2019 onwards. It ought to be noted that sufficient opportunity of hearing was accorded to the petitioners herein, who had also filed their responses. It ought to be noted that while notice dated so-and-so, and a meeting of the INC Legislative Party was called on 18/1/19. The notice stated that the members must compulsorily attend the meeting, otherwise action will be taken against them under the 10th schedule. The petitioners did not attend the party meeting on 18/1. Admittedly, the petitioners also refrained from attending the subsequent general body meeting on 16/2, as well as the assembly session. The resignations were submitted by the petitioners nearly 4 months after the disqualification petition had already been filed. Similarly, Malaj, when Sunil Prabhu asked them to attend the meeting, their answer was, you have no authority to. So it clearly falls within this dictum here, Malaj. Then para 38. Notably, while disqualification petition 1 to 16 were filed on 23/6 and disqualification petition 18 was filed on 27/6, the petitioner had filed an additional affidavit on 23/9, bringing on record the subsequent facts, including Eknath Shinde meeting the governor, staking claim to form the government, and taking oath as the chief minister on 36. The respondent MLAs supporting the government formed by Eknath Shinde in the confidence motion on 4/7, and many respondent MLAs serving as ministers in the government led by Eknath Shinde. The filing of the additional affidavit was objected to by the respondents. We filed that and they objected on the basis that the petitioner was seeking to amend the pleadings and bring in fresh facts. At that time, I didn't know the facts, they only came to be known later. That did not have a bearing on the alleged time and event when the members allegedly incurred disqualification. It was also claimed that the new pleadings would become part of the petition and the respondents will have to be given time to file additional affidavit. After careful consideration of these submissions, the additional affidavit dated 23/9 was categorically taken on record by the Speaker, Y daughter dated 2010. The facts mentioned therein thus became part of the pleadings and required consideration. Due to this, these facts subsequent to the filing of the disqualification petition were also considered by the Speaker in the impugned judgment, even though it was eventually held that the facts did not lead to the conclusion that the respondent incurred disqualification. Therefore, Maharaj, we say it is respectfully submitted that instead of appreciating the legality of the above actions in a holistic manner, the Speaker in the impugned judgments has considered some of the contentions in an isolated manner and held that the same be not established on erroneous technical grounds. The main contentions based on the undisputed acts of the respondents have either not been dealt with or rejected on the ground that the respondents themselves represent the political party. So what does he say, Malad? We said respondents became incommunicado. He says, how can I decide that question? Because we haven't put forth any. The reason was, Malad, that they went to Surat and they went to Guwahati. Where was the question? But anyway, we won't go into that, Malad. As I told your lordships, I am not on our acts. I am on the undisputed facts. Second is respondents remained absent in the SSLP meeting held on such and such. That is because they say Shinde is the real political party, which I have already addressed your lordships on. Respondents' deliberate absence. He says they are the political parties, so not relevant. Respondents' resolution purporting to change the whip. They say they are the faction, which is the real political party. Respondents acting in concert with EJP. They say that's a mere allegation. No inference can be drawn. Anti-party, anti-coalition statement. They say newspaper reports. Whereas in these matters, courts have relied upon newspaper reports because you can't lead evidence. Eknath Shinde meeting the governor, he said Shinde faction was the real political party. Therefore, it is respectfully submitted that the undisputed facts on record clearly establish that the respondents are liable to be disqualified under 2(1)(a). But it's just the finding of the speaker in the second table. Shinde faction was the real political, but we've already said all that. We've said all that. Let's not repeat it. Service of whips, we've said all that. Petitioners group had not complied with. Now, this is important. Item 3, petitioners group had not complied with the requirement of Rule 3.5 of the members Maharashtra Legislative Disqualification Rule. Rule 3.5 says that within a certain number of days, you can, condone the act of disqualification. So he says, since you have not said that I don't condone it, therefore I assume that you have condoned it. This is 3.5. That's how the logic is. As your lordship knows, under all these rules, within 20 days or so, if the party writes that he has incurred disqualification, but let's condone it, I don't want you to deal with it. In this case, I did not write. So he says the fact that I did not write shows that I have condoned. But I filed disqualification for this. So obviously I have not condoned. So this is the logic of the speaker. But there's a very, very flight of his imagination is really very compelling. Whips did not state that the whips did not, item 4, did not state that in case they are not followed, it would result in. Item 4, he says, whips did not state that in case they are not followed, it would result. They say the whip should have stated that in case they don't follow the whip, it will result in disqualification. Since it did, we did not state it, therefore, how can it be disqualified? Then comes to 5. No whip can be issued for election of the speaker since the candidate was not set up by any political party. When we are the party and they are in the house, whip will be issued. This is our candidate. This is the political party's candidate. This is also completely wrong, Mullahs. Then 6. Gogavale was recognized as the whip on 3/7/2022. Legislators who acted as per this whip cannot be faulted. But we are challenging the very appointment of that whip. This logic is also, Mullahs, something that needs to be. Then what else? That's it. Mullahs, I just want to read 2 paragraphs, Mullahs, in Kyoto. Last document is Kyoto, Mullahs. Which are the paragraph? The sin of defection. Sin of defection.
In the judgments compilation.
I'm sorry?
In the compilation.
Yeah, we've given it, Mullahs, just a new one. Mullahs. I'm sorry.
It's not there in this compilation.
I'm
It wasn't
sorry.
there in
Yes, yes. Which is the paragraph on this sin of disqualification? Sin of disqualification. You can mention it. 1 para 122, Mullahs. Yes, yes. Para 140, page 725 of this. No, sorry. It starts at page 86 of this compilation, Mullahs, and at 160, 160, Mullahs. Just add these 2 paragraphs and then I've done, Mullahs.
160.
160, page, paragraph 140 of this judgment.
140 on top.
Yes, top is that. My Lord Justice Mona just Bakshi have that. Kindly see, Mullahs, para 140.
10 schedule.
The 10th schedule was inserted in the Constitution by the 52nd Amendment, which came into force with effect from March 1, 1985, and is popularly known as the Anti-defection law. The statement of objects and reasons says that this amendment in the Constitution was made to combat the evil of political defection, which has become a matter of national concern, and unless combated, is likely to undermine the very foundations of our democratic system and the principles which sustained it. These are prescient words. So, Mullahs, my submission to your lordships is as a matter of interpretation. Please don't interpret it in the 10th schedule for allowing defections to take place. Because that's a sin. Karnataka judgment says the same. This amendment is therefore for outlawing defection to sustain our democratic principles. The 10th schedule contains 8 paras. Para 1 is the interpretation clause defining house to mean either House of Parliament or the Legislative Assembly, or as the case may be, either House of the Legislature of a state. The expression legislature party and original political party, which are used in the remaining paragraphs, are also defined. Para 2 provides for disqualification on ground of defection. Para 3 provides the disqualification on ground of defection is not to apply in case of a split, indicating therein the meaning of split. Para 4 provides the disqualification on grounds of defection is not to apply to a case of merger. Para 5 provides for the Speaker or the Deputy Speaker of the House of the People of the Legislative Assembly of the state, the Deputy Chairman and Council of States, or the Deputy Chairman of the state from the applicability of the provisions of the 10th schedule. And therefore, he says, Mullahs, at the heart of the issue is that the manner in which people violate the 10th schedule, the only defense is available under paragraph 3 and paragraph 4. Otherwise, make sure that you do not destroy the very foundations of our democratic process by encouraging, through an interpretation of the 10th schedule, defections that will take place. So if you say that, look, after 19th of July, he has got that much support, that's encouraging defection. Because when you are in power, this will happen. After 21st of June, this happened. Oh, but that's wholly irrelevant. In other words, Malas, you must freeze the event on the 21st of June and on the 19th of July. Anything that happens thereafter is encouraging defections, not dealing with the sin of defection. That's at the heart of the interpretation of the 10th schedule, Mullahs. And I pray to your Lordship, it's my considered, Mullahs, opinion, and I plead before your Lordship, Mullahs, to hold that Shiv Sena name belongs to Thackeray, to hold that the faction of Shinde cannot have the symbol. And the fact that they have enjoyed the benefit of that symbol is not a case of equity. It's a case of illegitimate use of a symbol. It should be frozen. If he can't have it, I can't have it, it has to be frozen. And the name belongs to me.
This is your alternate.
This is my alternate submission. You can't, he cannot create equity by doing something illegal from the inception. With those words, I'm deeply obliged. You've been very, very patient with me. I'm honored, to have argued this matter.
Thank you. Thank you.
माननीय सुप्रीम कोर्ट में वरिष्ठ अधिवक्ता कपिल सिब्बल का यह आक्रामक स्टैंड क्या वाकई शिवसेना के इस कानूनी दंगल की दिशा बदल देगा? माननीय कोर्ट इस पूरे मामले पर अब क्या रुख अपनाता है, इस पर पूरे देश की नजरें टिकी हुई हैं। आपको क्या लगता है, क्या वरिष्ठ अधिवक्ता कपिल सिब्बल द्वारा माननीय न्यायालय के समक्ष रखी गई यह मांग इस राजनीतिक विवाद का एकमात्र समाधान है? अपनी राय नीचे कॉमेंट्स बॉक्स में जरूर शेयर करें। जय हिंद दोस्तों।